A guardianship is a legal process whereby the court names someone other than the child's biological father or mother as the guardian of that child. That person who's named the guardian is the de facto parent of the child. That the guardian will have the decision-making factors, the decision-making power, and all the health, education, and welfare issues involved in the child's life.
Okay, and why is a guardianship even granted by the court?
Parents are inadequate in their parenting. It's as simple as that. Everyone's heard about the Department of Child and Family Services, etc. Everyone knows about them being called out, children being abused, neglected. Those are the reasons. Oftentimes parents, a lot of times because of emotional issues or because of substance abuse issues, aren't able to parent the child. Courts will then come in, or a party will then come in and say, I want to be named the legal guardian of this child. Oftentimes it's a grandparent or a brother or a sister.
And how does a person go about doing that?
You would file a petition for the court, with the court. Usually what we will do is we'll just set up an emergency hearing, just saying, this is an extreme situation, it's an emergency situation, this child needs to be protected now. And you file paperwork with the court. And then they'll have a hearing on that, usually within 2 weeks.
Okay, and what about if you don't file that? What happens with your general petition? How fast is that heard?
Well, again, if you file just the petition for guardianship, it's about 2 months before you're in fact in front of a judge. Most guardianships arise out of an emergency situation, so you usually have what's called an ex parte hearing. That's a quickie emergency hearing. But if in the 2 months from the time that you file your general petition, whether or not you decide to have a quickie emergency hearing, a lot of stuff's being done. The court appoints an attorney to represent the minor child. The court has a court investigator investigate you if you're the proposed guardian, so you've got to be clean, etc. And when you get there on the day of the hearing of the guardian,
that was going to be my next question. What happens at the hearing?
A lot of things can happen. If in the perfect world, everyone's going to be there and the parents are going to be there and everyone's going to be begging the court, please name you as a guardian of the child. It rarely happens that way. Usually they don't have the investigator's report that the court appoints. Usually don't have it by that time. The court will continue the hearing. Minors counsel, though, almost always has a report available for the court then. And if people show up and the parents show up or any other family member shows up or any interested party shows up and says, I object to that person, to Jane Doe or Tom Doe, from being named a guardian, the court will say, fine, we're going to continue this matter out and we'll set a trial on the matter to make a determination.
Okay. Now, if you are named the guardian after a trial has been held, or if there's an agreement between the parties and the biological parents, what happens? How do I show the world that I am the child's guardian?
The court will make an order. Very carefully, they'll make an order naming an individual as the guardian of the person and or the estate. Usually it's just the person if it's a child. And they will issue an order naming you the guardian, and then they'll issue letters of guardianship. And really, when you're going to the hospital at 2:30 in the morning and the staff at the emergency center want to know who are you and why isn't the parents here, you just show them your letters of guardianship and then suddenly you're the parent as far as they're concerned. So you'll have those two things, the order and then the letters of guardianship.
Anything else that would be helpful for someone contemplating a guardianship as far as what they should know or expect when filing the guardianship?
You'd better have clean skirts. That's an old expression from law school. You had better be fine yourself. You can't sit here and say, my daughter, because I'm the grandmother of the minor child, really called the ward when you're in these situations. You'd better be clean yourself, because they are going to do an investigation on you, because they want to be sure that this child's okay. The courts always, when it comes to children, are very, very careful to be sure that they're not going to go from one abusive situation into another abusive situation. But you don't have to worry. We're not talking about a traffic ticket in terms of your background.
Okay. Now, I'm going to move over to conservatorship. What is the difference between a guardianship and a conservatorship?
Age. It's as simple as that. You get a guardianship off of an individual from the date of birth to the date the child turns 18. It's no longer a child, an adult. It often happens here with special needs children too, which is another part of our frequently asked questions. There's a video we have on that whole issue. But a conservatorship is a guardianship. Think of it this way. It's a guardianship for an adult. And what you do is oftentimes it's an adult with just special needs that are severe special needs, severe disabilities. The most common one is people as they get older.
Okay.
Dementia sets in, inability to function in society, etc. Usually it's the children who come in and say, we need a conservatorship of my mom or my dad because they cannot take care of themselves, and someone's going to come along and take advantage of them.
Okay, and that would answer my second question, which is why a person would bring a conservatorship or a petition for a conservatorship. That makes sense. Now, the next question, how are we able to prove to the court that I need a conservatorship over my parents or a parent?
You have to. If not at the beginning, when you file your petition for conservatorship, you have to obtain from the treating physician of the adult that you want a conservatorship over. You have to obtain, have them fill out what's called a capacity declaration. Very simple form. But the doctor will say, what are their cognitive abilities? How in contact with reality are they? You can still file your petition for a conservatorship without having that. But the court's going to want it by the time they have any kind of a serious hearing. Because again, the courts look, when you're asking to take away the powers of somebody, of an adult, they want to be sure that adult's not being taken advantage of. Very, very, very careful about preserving the absolute maximum amount of personal liberty of an individual in a conservatorship.
Okay, and you answered my last question with that answer as well. Why is the court, or what's the court's concern about a person who may need a conservatorship and their freedom?
You're young, I'm older. I understand now just how important to me my personal liberty is. And the courts are aware of that because a lot of the judicial officers are older also. And just think, how many of your personal liberties would you like taken from you? You'd say, perhaps they'll have to happen, but it better be very, very good reasons for doing that. And the courts have got an antenna that shoots out right away as if someone wants mommy or daddy's money, etc. No. So it's just a matter of protect the adult. If there's legitimate reasons, absolutely, in a minute they'll grant a conservatorship.
Here at Schuster Law Group, our mission is to take a genuine interest in our clients, understand their objectives, and meet or exceed their expectations. So call now, 562-464-3764, and visit our website at www.schusterlawgroup.com.